Contracts exist in labor law just as they do elsewhere. And while I've highlighted the general principles here, today we will take a closer look at contracts in labor law.
Welcome to YD. Why do Germans do things the way they do?
I'm not a lawyer, so please refer to the sources or consult a solicitor for legal advice. In principle, there is freedom of contract. So an employment contract can in principle be also concluded verbally or by implied action. If a company calls an applicant and asks if they can come by tomorrow morning and they agree, or if you send an email to an acquaintance asking if they can help out tomorrow morning and they show up the next morning and work with you, in both cases an employment contract would already have been concluded. However, under the Gesetz über den Nachweis der für ein Arbeitsverhältnis geltenden wesentlichen Bedingungen, Act on the Proof of Essential Conditions Applicable to an Employment Relationship, Nachweisgesetz in short, which came into force on 1st of August 2022, basic agreements must be recorded in writing. Even before this, it was always necessary to record fixed-term contract in writing, for example. In our case of the acquaintance who shows up the next morning to help, at least the following would have to be recorded in writing and signed by both parties on the first day of work. Name and address of both parties to the contract, what means the employer and the employee. The composition and amount of remuneration, in our case perhaps a specific hourly wage. Reference can also be made here to a collective agreement if, for example, you were hired under A7 or EO1 of a specific collective agreement. And also the date and method of payment. The agreed working hours, agreed breaks, and in case of shift work, the shift system. After 1 week at the latest, the law states on the 7th calendar day, not 7 working days, the following information must also be exchanged and signed. The start date of the employment relationship. For fixed-term employment relationships, the end date or the foreseeable duration. For example, if you were hired for a project or as a maternity cover where the end date is not precisely known. The place of work or specific places of work, or whether the employee is free to choose the location. I've explained the difference between home office and mobile working here. A brief description of the work to be performed. Reference can also be made here to an attached job description. This should actually exist for every job. If agreed, the duration of the probationary period. In the case of on-call work, pursuant to Section 12 of the Teilzeit- und Befristungsgesetz, Part-Time and Fixed-Term Employment Act, the agreement that the employee must perform his or her work in accordance with the workload, the minimum number of hours to be remunerated, the time frame determined by reference days and reference hours that is set for the performance of the work, and the period within the employer must notify the employee of the working hours in advance, if agreed possible, of ordering overtime and the conditions for doing so. We can see here that there are a lot of points to be covered which some people have simply overlooked. Who concludes a contract with whom, when you start, and how you are paid was probably clear to most people. But if I'm supposed to work 40 hours a week, then I must also state whether I'm required to work overtime at all and under what circumstances. If this is not stated, I do not have to work overtime. If I'm supposed to work shifts, it must state what the rhythm is and how it can be changed. If I am to fill in as a temporary worker in a restaurant, it must state how far in advance the boss will tell me that I have to work. A phone call saying, "Can you come in, please? The place is packed," is not sufficient notice. If the employee actually comes in, that's nice of them. And then there are the points in red which must be set out in writing and signed within 1 month, such as the duration of the annual leave. Even a cleaner or temporary worker on a mini job basis is legally entitled to holiday leave, a possible entitlement to further training, a possible company pension scheme, information on termination, notice periods, and the note that both sides must submit notice of termination in writing. A verbal statement such as "you are fired" has no effect in Germany. And a possible reference to applicable collective agreements, works agreements, or similar. For example, the works agreement on flexi-time may be part of the contract stating the earliest and latest time at which the employee must be at the office on working days. The Nachweisgesetz is actually more important for the employer because a violation of one of the notice periods or insufficient or incorrect information is an administrative offense that can be punished with a fine of up to 2,000 euro in individual cases. If you dismiss the deadline on the first day and after 1 month for a new employee, you could be asked to pay twice, and if that happens with 3 new employees, it can be a big burden for a small business. For this reason, written contracts before the start of work are actually the norm. Of course, all this information should be included in the contract. Incidentally, anyone who was already employed before the 1st of August 2022 must receive the information if they request it, and then also within 7 days for the items 1 to 10 and the rest within 1 month. The written employment contract presents by an employer are usually standard templates, whether downloaded from the internet in the case of small business or created by the Human Resources Department for this type of employment. This is, of course, more convenient for the company as information is always very similar and it saves time. However, this can also be good for the employee as inadmissible standard clauses are usually at the expense of the employer who has presented the contract. A classic example is all overtime is covered by salary. As we have seen the Nachweisgesetz, the circumstances and extent to which overtime is to be worked must be explicitly described. It is almost always inadmissible to cover all hours with the existing monthly remuneration. This means that there is no regulation on this, and therefore every single hour must be remunerated. The correct approach would be to specify a reasonable amount, which must generally be less than the weekly working time. For example, the salary covers 10 hours of overtime per month. Any additional overtime will be remunerated separately on the basis of the monthly remuneration with a 10% surcharge. In the case of women, there are said to have been clauses that exclude pregnancy. For example, the employee undertakes to refrain from becoming pregnant for 2 years from the start of employment. If she fails to comply with this obligation, she must expect immediate dismissal. This is inadmissible and can be ignored. Arbitrary revocation is also inadmissible. If an agreement states that it can be revoked by the employer at any time, whether it concerns a special payment, additional holiday, or home office arrangement, this is generally not the case. If something can be unilaterally cancelled, the reason for this must be stated in the contract. A general voluntary reservation for any special payment is also inadmissible. Exclusion periods that are too short. Claims lapse if they are not asserted within 1 month. This may refer to incorrect working time calculation, incorrect payroll accounting, or missing travel expenses, and is therefore inadmissible. If this period is too short, usually less than 3 months, the statutory period of 3 years applies. Contractual penalties if the employee does not show up at the start of the contract or does not comply with the notice period, provided that these contractual penalties do not exceed 1 month's salary or the notice period in the event of termination during the probation period. In fact, some companies are affected by the fact that applicants sign a contract but then receive a better offer during their application process and want to accept the second offer. For this reason, some companies require insurance to ensure that termination before start of employment is not possible, or impose a contractual penalty if the employee does not show up. This is generally permissible, but may not exceed the corresponding remuneration for 2 weeks notice period during the probation period. Sometimes there are also clauses for employer financed further training. If, for example, the employee undertakes further training in hazardous goods management, which they could also use in other companies, such an agreement may stipulate that the costs must be repaid if the employee resigns within a certain period. It would be inadmissible to specify an indefinite period and always demand the total amount. A period of 6 months would be permissible if the training lasts 1 month, or 5 years if the training lasts more than 2 years. The employee undertakes to perform other reasonable tasks if necessary, possibly also at a different location. There are two errors in this wording. Firstly, the wording does not state that the task must correspond to the previous task. I cannot instruct the accountant to clean the windows. And secondly, the location is not specified here. Whether the contract is sent by post, as before, or a signed copy is sent by email, printed out, scanned, and returned, is probably irrelevant in this day and age. You have a copy yourself. If you have to sign it on site, you should take the time to read it carefully, unless you have already been sent a sample. But even then, you should check no incorrect wording has crept in. If the agreed holiday or working hours are suddenly missing for the contract, then both sides have signed it that way. If the contract is in German but your German language skills are not sufficient, you should seek assistance, at least from a translation app, or better still, from an expert, possibly a solicitor. Once you have started work, you should check your contract from time to time to make sure that everything is still correct. Is your salary paid on time? For salaried employees, this is often at the end of the month, but for hourly wage earners, it is the beginning of the following month. In any case, no later than the 15th of the following month. Monthly transfers to a current account are the standard for salary payments in Germany. If changes are made retrospectively, they must be agreed jointly, as with a contract. If an error occurs and an overpayment is made, the money is usually deducted from the next salary payments. At the end of the contract, the company may demand repayment. Regular repayments in cash are a clear indication that the company is defrauding everybody, its employees and the tax office and social security authorities. So keep your eyes open when signing anything. Remarks, additions, and comments in the comments. Thank you for your attention. See you in the next video.